Good afternoon, gentlemen.
Good afternoon.
And ladies. All right. The reason I've called you come in before I decide to issue a writ as to I need to hear argument as to since this case has been going on for a while. I assume it's the same case. No, correct, Mr. Mandel? No, it's a new case.
Your Honor, this is Sam Zeskind of White Sororita, also for the city of Homestead. This is a different case than we were previously before you on.
How come why am I so confused in that respect?
This is another public records case. This matter was originally before Judge Diaz. The city had moved to dismiss. Judge Diaz granted it, and after plaintiff amended, he also moved to disqualify Judge Diaz, who then entered an order of recusal, and the matter got transferred to Your Honor.
Okay. And how did that happen? I have no offense, but how did I get so lucky, Doctor? Although I'm familiar with the cases, so maybe that's why I got so lucky.
I have no idea how they select the judges, Your Honor.
It's a computer, supposedly. But anyway, I'm fine. I just want to make sure that I want to hear argument for the issuance of the writ. And let me see if we can shortcut this. Is there an objection?
Well, Your Honor, I think that the question really boils down to whether or not the petition on its face is facially sufficient to state a claim. The city's position is that it's not. The city's position is that on the face of the complaint, it's clear that plaintiff's claims are barred by collateral estoppel. That's the basis of the city's pending motion to dismiss, and that it's apparent on the face of the complaint that these are the very same issues and arguments already raised and ruled on by Judge Riebel, and then decided by the third DCA in favor of the city. The same application of the same exemption to the very same document, Your Honor.
Well, shouldn't that be brought forth on the order to show cause your response?
It certainly can, Your Honor. If Your Honor's belief is that the petition on its face is facially sufficient, then the city would absolutely raise that as part of its response to an order to show cause.
Okay. Mr. Mandel, you wish to say anything, or are you taking Mr. Zeskind's lead?
Letting Mr. Zeskind take the lead on this one, Your Honor.
Okay. Doctor, is there anything you want to say?
So, Your Honor, real quickly, the only argument they made in their motion to dismiss is collateral estoppel. Motion to dismiss tests the sufficiency of a complaint. For them to make their argument on collateral estoppel at a motion to dismiss, they have to go outside the four corners of the complaint, and they're basically couching an affirmative defense as a motion to dismiss, going outside the four corners of the complaint, which itself should be barred. Lastly, I would say their whole motion for collateral estoppel is frivolous because they do not meet the elements, and they know this. There was an initial request I filed that was litigated. In that request, they claimed there were 5 responsive documents, and they were all exempt. The third district specifically held they were claiming exemption in one case based on a notice of intent I'd filed in another case. The third district held that the exemptions were valid until all issues related to the notice of claim were settled. They were settled several months before I refiled the request, and you can know it's not the same facts because the first time they said all 5 documents were responsive and exempt. This time they gave me 3 of the documents admitting the exemption no longer applies. They're claiming an exemption for 1 document. The 5th document they have not claimed an exemption for, and they refuse to provide me. Furthermore, there's a second set of records that contains 2 other people filed an identical request and got 122 pages of records. The city admitted in court there were 500 records responsive. None of those 122 records have ever been given to me in this request. Furthermore, the additional records are withheld as being exempt of the 500. Many of those would no longer be exempt, and they have not been provided to me either, Your Honor.
I got it. Anything else you want to say, Mr. Zeskind?
Yes, Your Honor. I'd just like to point out quickly that the arguments regarding collateral estoppel, the law is pretty clear that if it's apparent on the face of the complaint that the prior proceedings are incorporated within the complaint, that it is appropriate to determine a motion to dismiss. That's part of the argument that was made and considered to Judge Diaz when he heard our initial motion to dismiss. And Your Honor, I'd just like to point out that on the transcript of that prior hearing, Judge Diaz's ruling, beginning on page 10, when addressing on line 22, when addressing the city's motion to dismiss, Judge Diaz stated, "I find that upon review of your complaint," and this is him addressing plaintiff, "the motion that has been filed, you failed to state a cause of action for injunctive relief, declaratory relief, and most certainly, you have failed to state a cause of action for the extraordinary writ you are seeking against the city." There's been no substantial material change in the allegations made by plaintiff. The complaint on its face, still, it's apparent that their collateral estoppel applies and that the same arguments and issues already ruled on by the third are trying to be relitigated here. So we think that, on its face, that the complaint is insufficient and collateral estoppel applies. And
Let me ask you a question, Mr. Zeskind. Doctor has 3 counts, one for mandamus, one for deck action, and the other one for injunctive relief. Should they all be taken? The rule to show cause should be issued on which count?
only the mandamus.
Just want to make sure the record's clear. Okay, so this is what I'm going to do. I believe his count 1 is sufficient to issue the rule to show cause, which you have 20 days to respond. As far as count 2 and count 3, that the motion to dismiss will be heard separately on that. At another hearing where you can give me a memo of law, and doctor can do the same thing if he wishes. So I don't want to commingle them all. I think it's not fair for the doctor to do so. So I'm going to issue the rule. I'm going to issue the rule on the. You have 20 days to answer that, and when I issue it. And then we'll set your motion to dismiss on the other 2 counts for a special set hearing, 30 minutes or less. Doctor, you know how to do that?
That sounds fair to me, Your Honor. The only thing I would ask is the material witness to this case that knows everything is Mr. Zeskind. And earlier today, I filed a motion to disqualify him from being both a witness and advocate for the city under Florida rules regulating the Florida Bar 4-3.7, as well as a motion to pierce attorney-client privilege for the crime fraud exemption. I would ask if we could get a hearing for those, and if so, I could. Obviously,
I wasn't aware of that. So obviously, we need to dispose of that before he continues with the case. He continues, but that's what Mr. Mandela is here. I suspect now.
That's what I was going to ask you. If we're issuing the alternate writ, we should be past the pleading phase at this point, and I would need to get discovery to defend against what they respond to. And I filed the motions. I would ask for a hearing on the 2 motions I filed today to see if we can move forward with discovery by taking Sam Zeskind's deposition.
Well, I don't have a problem. I don't have a problem doing that, Mr. Doctor, to hear the motion to disqualify. So it's what's the other motion? But let me just bring it to your attention that I'm starting a trial on Monday. That means I'm gonna have to work in those hearings in the process.
I understand, Your Honor. The only way I would ask that we give this as much priority as possible, but I don't want to stress you, and I'm not going to demand an immediate hearing. I would just request that I get discovery before I have to respond to, or we go forward for the hearing on mandamus or the hearing on counts 2 and 3.
Okay, but they get a chance to respond to the mandamus, and then we'll go from there. Then we'll address your issues before that, but before we have a full hearing on it. Absolutely.
I appreciate that.
Okay.
Honor.
So, Mr. Zeskind and Mr. Mandela, you've got my ruling.
Yes, Your Honor.
Okay, gentlemen and ladies, a pleasure to see you again. I guess it's one of those things that follows me around, which is okay.
Your Honor, do we need to file an order, or do they just have 20 days from today to respond?
Well, no, I'll file the I'll send you the order, unless you want to waive that, and then you just send me an order saying you have the 20 days.
Your Honor, I prefer that Your Honor
Okay.
issue the.
That's fine. That's the proper way to do it. That's fine.
And then while I need to serve them the order, Your Honor, or they consider it served through the electronic service?
No, we've had a hearing. I'm sure you'll be okay with the service of over electronic.
Yes, Your Honor.
Okay.
That's
All
all
right.
I have, Your Honor. Thank you very much.
Anything else? All right, I'll let you, Mr. Doctor, and I don't know if Mr. Mandel is going to take over for the motion. I need you all to, at some point in the next 5 days, contact my office and let's set a date for the disqualification and the other issue. And then we can deal with the motion to dismiss at a later time.
I'm sorry, you want me to confer with them and we'll meet by Zoom or actually
Well-
come presently to your office?
No, we'll meet by Zoom,
Okay.
for the hearing.
Okay.
Okay? All right, thank you very much. Have a
Thank you
good
so
day.
much, Your Honor. Have a great May
Thank
4th.
you, Your Honor.
Thank you, Judge.
5th, Cinco de Mayo.
I'm not there yet.
Have a great one. Thank you again.